Regulation. Protected areas law should support regulation of activities in and near protected areas. Regulated activities can include access to all or part of a protected area, use of the area and its resources, and activities that may threaten the site's conservation objectives, such as activities that pollute or damage ecosystems. Protected areas law should identify which activities are prohibited, which activities are permitted subject to a valid permit, and which activities are generally authorised and may be undertaken without a permit, subject to general rules or conditions. How activities are regulated depends on international obligations, conservation objectives, and the protected area category of a specific site. For example, in Category 1A, strict nature reserves, more activities may be prohibited or may require a permit. In Category 5, protected landscapes or seascapes, more activities may be permitted or generally authorised. Different regulations may apply to different zones within a single protected site. Protected areas law should also provide for special action in the event of an emergency. Environmental impact assessment. A key tool for regulation of activities affecting protected areas is an environmental impact assessment. An environmental impact assessment is an assessment of the possible environmental, social, economic, and cultural impacts of an anticipated activity or project. The Protected Areas Law itself can require environmental impact assessments as part of the permitting process for certain activities. Or environmental impact assessments can be required by separate environmental legislation. In these cases, Protected Areas Law can reference the requirement and clarify its application in the context of protected areas. Compliance and enforcement. Effective regulation of activities in and near protected areas depends on effective compliance and enforcement. There are several main approaches to compliance and enforcement. Under the command and control approach, law creates civil or criminal penalties for those who do not comply with legal rules and standards. Penalties can include fines or imprisonment. Under the incentive-based approach, law provides incentives such as subsidies, tax exemptions, information or technical support to encourage compliance with conservation standards and objectives. Under the co-regulation approach, law prescribes standards and allows citizen organisations, industry groups, landowner associations, indigenous peoples, and/or communities to develop their own mechanisms to ensure compliance. Under the self-regulation approach, citizen organisations, industry groups, landowner associations, indigenous peoples, and/or communities create their own standards and mechanisms to ensure compliance with these standards. Protected Areas Law can provide for a combination of these approaches to suit different protected area categories and governance types. In all cases, Protected Areas Law should designate authorities responsible for developing and implementing compliance and enforcement mechanisms, and describe the powers and duties of those involved in compliance and enforcement. Define offences and penalties related to non-compliance with the law or regulations under the command and control approach, and provide for incentives for compliance under the incentive-based approach. Financing. Effective regulation and management of protected areas depends on adequate and sustainable financing. Financing can come from the central, regional, or local government budget, tourism or user fees, donations and other external assistance, incentives for private or community conservation through tax exemptions or other support, or payments for ecosystem services, where a government agency, international organisation, or private company pays for a specific benefit provided by the protected area. For example, a water utility can pay for the conservation of a watershed because it keeps the water clean and reduces costs of artificial purification. Carbon markets, biodiversity offsetting schemes, and conservation banking mechanisms are also forms of payment for ecosystem services. Main messages. Protected Areas Law must provide for regulation of different activities in the protected area. Protected Areas Law should provide for impact assessment procedures to inform decision-making relating to activities undertaken in the protected area. Protected Areas Law should include a range of measures to promote compliance with and enforcement of requirements and regulations. Protected Areas Law and associated laws should include provisions to ensure the sustainable financing of protected areas.